These are children. There's a question here. Like, why is there a question here? Why is anyone at all providing unsafe and unsanitary conditions to children? Because if I did that, I would go to jail, right? If I had a child and I kept my child unsafe and I kept my child unsanitary, I would be guilty of some kind of child abuse and I would go to jail. Vulnerability of minors means you give them food and water and a toothbrush and toothpaste and you let them sleep. I'm saying these words out loud. Does this have to be said? The people who are advocating for it are either incredibly stupid or actually evil.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
If you've ever heard of the Flores Agreement, this is Jenny Lizette Flores. This is also in the United States Court of Appeals for the Ninth Circuit, and this is against the Attorney General, the Secretary of Homeland Security, the Department of Homeland Security, U.S. Immigration and Customs Enforcement, ICE, and U.S. Customs and Border Protection, or CBP. And that includes, of course, William Barr, who's the Attorney General, and Kevin McAleenan, the Secretary of Homeland Security. This is recently filed. This is filed August 15th, 2019. This is an opinion. So this is not somebody's complaint. This is not an answer. This is not a motion to dismiss. This is the judge's opinion. And which judge is that? 3 judges. Tashima, Fletcher, and Berzon, and the opinion was written by Judge Berzon. The panel dismissed for lack of jurisdiction an appeal brought by DHS, Department of Homeland Security, and its component agencies of the District Court's June 2017 order, granting in part the motion of a plaintiff's class to enforce a 1997 settlement agreement with the government which set a nationwide policy for the detention, release, and treatment of minors detained in Immigration and Naturalization Service custody. In 1997, the United States entered into a settlement with a class of minors subject to detention by U.S. immigration authorities. The settlement agreement, incorporated into a consent decree, requires immigration agencies to hold such minors in their custody in facilities that are safe and sanitary. So those are going to be keywords. The agreement also requires the government to treat these minors in its custody with dignity, respect, and special concern for their particular vulnerability as minors. So children are especially vulnerable. Plaintiffs filed a motion in district court to enforce the agreement. The district court found that the government was violating the agreement by detaining minors in unsanitary and unsafe conditions at Border Patrol stations. These findings were based on evidence that minors in U.S. Customs and Border Protection custody were held in conditions that deprived them of sleep and did not provide adequate access to food, clean water, and basic hygiene items. The court also found that the government was violating the agreement by failing to consider minors for release as specified in the agreement and by detaining minors in detention facilities not licensed for the care of minors. The district court ordered and enforced various paragraphs of the agreement and also directed the government to appoint an internal juvenile coordinator as contemplated by the agreement to monitor the government's compliance with the agreement and to report to the court. That is sort of normal in custody cases. You would have an independent attorney or representative who would interview the child separately so that a plaintiff or defendant parent or other interested relative or someone couldn't influence the child. The same with the courts. So the prosecution attorneys wouldn't be interacting with the child in that way. You would have any questions or such go through sort of
like a trusted person or something like that?
Yeah. The parties agreed that this court has jurisdiction over the appeal of this post-judgment order only if it modified the agreement. The government argued that the district court's order did modify the agreement by requiring the government to provide specific hygiene items and adequate sleeping accommodations not listed in the text of the agreement. The panel held that the district court's order did not modify the agreement, but instead interpreted the agreement's requirements that minors be held in safe and sanitary conditions consistent with the government's concern for the particular vulnerability of minors. The government also argued that the district court modified the agreement by concluding that it requires the government to consider releasing class members subject to expedited removal. The government contended that this interpretation of the agreement was inconsistent with the Immigration and Nationality Act and related regulations, primarily with the expedited removal provisions, which provide that non-citizens in expedited removal proceedings shall be detained for further consideration of their applications for asylum. The panel held that, rather than modifying the agreement, the district court appropriately interpreted it as consistent with both the INA and this court's prior interpretation of the agreement. Regarding the government's argument, the district court erred in concluding that the agreement prohibits the government from detaining minors in secure, unlicensed family detention centers. The panel noted that the district court addresses this issue directly in its earlier July 2015 order, that although the government appealed that order, it did not on appeal challenge the district court's holding on this issue. The panel concluded that this issue belatedly raised in this appeal was not properly before the court. Because the panel concluded that the district court's order did not modify the agreement, it dismissed the appeal. So that's a little bit complicated. So we're going to go over the whole opinion here. I don't think it's going to be that terribly long. It's only another 12 pages, and it's these partial pages here. This case stems from a 1985 lawsuit filed on behalf of a class of minors detained by U.S. immigration authorities. After considerable litigation, the parties negotiated the agreement. It was entered by the district court as a consent decree in 1997. The agreement remains in effect today. The agreement included a specified termination date, but in 2001, the parties stipulated to extend the agreement until 45 days following defendants' publication of final regulations implementing the agreement. The government has proposed regulations, but the regulations have not been made final. So that's why the agreement is the thing that survives to today instead of a new law, because the agreement was for them to implement final regulations, which means having to go through a implementation process or notice and comment process to implement said regulations. Depending upon the kind of regulations they are, but I'm guessing these are the notice and comment kind of regulations. The agreement sets out nationwide policy for the detention, release, and treatment of minors in the custody of the INS. It requires the government to place each detained minor in the least restrictive setting appropriate to the minor's age and special needs, provided that such setting is consistent with its interests to ensure the minor's timely appearance before the INS and the immigration courts to protect the minor's well-being and that of others. The agreement's provisions create a presumption in favor of releasing minors and require placement of those not released in licensed non-secure facilities that meet certain standards. Under paragraph 12A of the agreement, following arrest, the INS shall hold minors in facilities that are safe and sanitary and that are consistent with the INS's concern for the particular vulnerability of minors. The agreement continues, facilities will provide access to toilets and sinks, drinking water and food as appropriate, medical assistance if the minor is in need of emergency services, adequate temperature control and ventilation, adequate supervision to protect minors from others, and contact with family members who were arrested with the minor. Within a few days of initial detention, 3 days if a suitable detention facility is located and has space available, or 5 days in all other cases, the government must ordinarily choose between two options for placement. The first and preferable option discussed in paragraph 14 is releasing the minor to a parent, legal guardian, adult relative, or another capable and willing designated adult. Alternatively, under paragraph 19, the minor may be placed in a facility licensed by an appropriate state agency to provide residential, group, or foster care services for dependent children. Licensed facilities must be non-secure as required under state law, meaning they don't lock the doors to keep the kids in or something. I don't know what that means. Anybody look up what a non-secure facility is? I'm assuming that they're comparing it to like a jail. A jail would be a secure facility, and this is not a jail. So maybe it's still, in a sense, that has security, but I don't think it means that it's a jail. Finally, paragraph 28A provides that an INS Juvenile Coordinator shall monitor compliance with the terms of this agreement and shall maintain an up-to-date record of all minors who are placed in proceedings and remain in INS custody longer than 72 hours. In May 2016, the plaintiffs filed a motion to enforce the agreement. The plaintiffs alleged that despite earlier such motions and resulting orders enforcing the agreement, the government continues to violate it by detaining class members in unsafe and unsanitary conditions at Border Patrol stations and by detaining minors in secure, unlicensed facilities, as in secure like the jail, and unlicensed as in not licensed to provide childcare. The plaintiffs requested that the district court address these violations by appointing an independent monitor. In June 2017, after an evidentiary hearing, the district court granted in part plaintiffs' motion to enforce. In its order, the court found that the government was violating the agreement's express requirements to provide adequate access to appropriate food and water and adequate temperature controls at a reasonable and comfortable range. The court further found that although the agreement makes no mention of the words soap, towels, showers, dry clothing, or toothbrushes, these hygiene products fall within the rubric of the agreement's language requiring safe and sanitary conditions. Certain Border Patrol stations, the district court found, were violating paragraph 12A of the agreement by failing to provide such sanitary necessities. These are children. There's a question here. Why is there a question here? Why is anyone at all providing unsafe and unsanitary conditions to children? I don't understand, because if I did that, I would go to jail, right? If I had a child and I kept my child unsafe and I kept my child unsanitary, I would be guilty of some kind of child abuse and I would go to jail. So to me, and I'm not trying to be extreme here, but to me, the same standard should apply. And that doesn't sound extreme at all to me. The exact same freaking standard should apply, and the people who are keeping these children in unsafe and unsanitary conditions should also be charged with child abuse. That is nothing less than what should be charged, in my opinion. The district court also determined that although the word sleep does not appear in the agreement, where the defendants have set up conditions that allow class members to sleep in the Border Patrol facilities is relevant to the issue of whether they have acted in a manner that is consistent with the INS's concern for the particular vulnerability of minors, as well as the agreement's safe and sanitary requirement. Citing evidence that many minors in Border Patrol custody are forced to sleep on concrete floors with no bedding aside from pieces of thin polyester foil, and are subjected to cold temperatures, serious overcrowding, and constant lighting, the district court found that the government was violating the agreement at certain Border Patrol stations by holding children in facilities that deprived them of adequate sleep. Again, if I was sending my child to school without adequate sleep every day, and if the school called child services and child services investigated and found that I kept the lights on in my child's bedroom all night, bright lights, child did not want on, and we're not helping the child sleep, not trying to stay safe from monsters and all that. I understand. I was a kid too. I had monsters under my bed, and a light on is fine, like a night light or whatever. This is not a night light. These are the regular overhead lights that are lighting up the room for general lighting, so that everybody can see what everybody's doing, and that's not conducive to sleep. If they had done something to make it comfortable to sleep, give everybody like little face masks or something, at least you could make an argument that they're trying. I don't even see that here. This just seems like serious deprivation of children's rights, and certain people support this crap. I know that I have parents who are on a side of the immigration issue that I disagree with, and they seem to think this is all just fine because this all acts as a deterrent. Why would you bring your child here if we're going to make it terrible for you? Is a level of thinking I just can't approach in my brain. Like, I don't make the mental leaps to think that the children have to be harmed in order to accomplish some sort of immigration goal. But that's getting dangerously close to political. The court also found that the government was failing to make and record ongoing efforts aimed at releasing or placing class members in violation of paragraph 14 of the agreement, and was detaining class members in secure, unlicensed facilities in violation of paragraph 19. The district court declined, however, to appoint an independent monitor, as the plaintiff had requested. Instead, it directed the government to identify an internal juvenile coordinator in accordance with paragraph 28A of the agreement. The court instructed that the juvenile coordinator, once appointed, will monitor compliance with those terms of the Flores Agreement, which this court has found must be enforced, and shall report directly to the court regarding the status of defendants' compliance. And I'm sure that the non-independent internal juvenile coordinator will not be biased at all. This court has appellate jurisdiction. The parties agree that the court's order did not grant, continue, dissolve, refuse, or refuse to dissolve an injunction. So they're talking about how they have jurisdiction over the case. We're going to skip this. This is not the part that I wanted to go over. The government contends that by interpreting paragraph 12A in the body of its opinion to require that Border Patrol stations provide the most basic human necessities, accommodations that allow for adequate sleep, essential hygiene items, and adequate clean food and water, and the district court modified the agreement's requirements that minors be held in safe and sanitary conditions, and this somehow then invalidates jurisdiction. So they're trying to invalidate jurisdiction by saying that the district court has modified the agreement. The district court is instead saying, no, we're interpreting that safe and sanitary and vulnerability of minors means you give them food and water and a toothbrush and toothpaste and you let them sleep. I'm saying these words out loud. Does this have to be said?
This is disgusting.
You would never do this to your own child, but it's totally okay for these people to do it to somebody else's? Absolute BS. The people who are neglecting these children are degenerative. I have words that I can't say on YouTube.
I am ashamed to share a race with these people. Like, I think humans.
Yeah, there you go. You can say it that way. You can say it that way. These, I can't even use mentally ill people who would visit this neglect upon children because they feel they are on a righteous crusade against South American and Middle American people who are often of a different skin color. It is nothing less than an egotistical power trip of a crusade, a shutting of the door. After we got into the country, my family's immigrants, and then what? We, the people, just turn around and close the door? Let alone that these people have the right to make an asylum plea and have it evaluated by a court. And if their asylum plea fails, sure, they can be deported. If their asylum plea does not fail, if it succeeds, then we grant people asylum. Don't forget that the United States had tremendous influence in Middle and South America over the last several hundred years, since its existence. America has been meddling in South and Middle America.
Some of these people are displaced because of us.
Yeah, like I can't say that there's not any case where somebody didn't need to come here for asylum and just tried to cross into the country illegally. Sure, let's discuss all the numbers, but what we're not doing is discussing. And what we're doing instead is neglecting children, and people are saying things like, I shit you not, absolutely shit you not. I hear things like, but they're committing a criminal act. You still give criminals toothbrushes and toilets and let them sleep. Are you kidding me? I cannot believe that that is how easy it is for a grown adult mother to dismiss the mistreatment of a child.
I think the fact that they are seeking asylum means that the place that they're coming from is already pretty horrendous. And so in order to deter, because the idea behind refugees is that we have a moral imperative that if somebody's life is so horrible through no fault of their own, that we can accept a certain number of those people and give them an opportunity to have a life that is not hell.
Yeah.
And so if they are coming here to claim asylum, their life is already hell. And so in order to deter them, you have to advertise to everybody, your life will be more than hell. We will treat you less
Yes.
than even subhuman. And that
We'll
is,
treat you as badly as what you're running from, or
we'll
worse.
treat you worse than what you're running from. And that is sickening.
That is appalling. That is sickening. That is not American. That is not patriotic. That is not a United States value. We do not want to deter people who are trying to flee from tremendous oppression, violence, and death, or worse.
The word un-American is used as rhetoric, right? Like, that's un-American. It's like a word that is used.
This is not rhetoric. That is literally not an American value. This is akin to torture. If you are depriving someone of sleep and clean teeth, that's torture, and you're doing this to children, like, it's already bad enough that you would do this to a vulnerable person to begin with. So a vulnerable adult is getting this treatment as well. Remember, like, these are also vulnerable adults who are getting treated like this. But it's especially egregious now that you're doing it to their kids. We don't like the law that you broke, so we're going to neglect you to deter you from breaking this law and trying to enter the country illegally. We can have a conversation all day long about the illegal immigration problem and how it should be solved. The decision here was made to solve the problem by neglecting children. And people wonder why I am against a certain political administration and why I rail against that crap. These are children who are going to be damaged for life because they had a traumatic experience in Customs and Border Protection. Why not be an example? Why not show them what a wonderful country we are and handle their case properly and inform them how they can come to the country properly? You know, there's a million answers here that don't involve neglecting children. I just gave you one simple one. Probably too simple, probably been done before. We can have a conversation about it. It does not need to resort to the neglecting of children. This is a court that 2 years ago appointed someone to investigate, and it turns out that the investigation discovered all this neglect.
And the people doing it have kids too, right? Like, statistically speaking, a bunch of them have kids.
Yes.
So on the one hand, they're probably treating their kids well, right? They're probably not neglecting their kids. And then on the other hand, neglecting the kids of somebody else. I mean, do they put the kids in their kids' shoes? Like, do they ask the question, hey, what if this was my kid? Would I want them to be treated this way? Probably not, right? Like, so they don't even consider them to be human children then at that point, right? Like, because I have a hard time believing that a mother or a father would treat a kid that way if they believed that they were kin, you know, that they were the same.
Yeah. To me, it takes a special kind of evil. It's hard for me to label people as evil. I definitely think people are stupid, but it's hard for me to go so far as to label certain people as truly evil. But this behavior is nothing short of evil. It's maybe misguided to the point that it's gotten to evil. Maybe this is a thing where the people don't realize what they have voted for. I'm certainly open to forgiveness and all that, but there certainly has to be, pardon the term, there has to be reparations here. There has to be a remedy that involves repairing the damage that is done to these children. So 2 wrongs, as my mother would often tell me, 2 wrongs don't make a right. And so what has happened here is we have embodied the 2 wrongs make a right metaphor. Someone has attempted to come into the country illegally or otherwise been accused of something that requires them to be detained. You know, so we don't know if they're coming into the country illegally. Maybe they're seeking asylum or something. Who knows? They're allowed to seek asylum. They're not allowed to enter the country illegally. So where's the line there? If a person is desperately seeking asylum and they didn't feel safe crossing at a traditional border crossing or the, you know, regular structured border crossing, were they trying to get into the country illegally or were they trying to seek asylum? Of course, someone who wasn't seeking asylum might claim to seek asylum because that's a way to get in. What if the case is granted? The answer is no if you don't ask. I get it. We can talk all day about how you handle that. This is not the way. The people who are advocating for it are either incredibly stupid or actually evil. So they go on to argue about whether the interpretation of the release provisions also invalidates jurisdiction, and I'm just going to skip that. Finally, the government argues the district court erred in concluding that the agreement prohibits the government from detaining minors in secure, unlicensed family detention centers. The district court addressed this issue in July 2015. So we've had this answer since July 2015. Although the government appealed that order, it did not on appeal challenge the district court's holding on the issue. A party cannot offer up successively different legal or factual theories that could have been presented at a prior request for review. The issue is belatedly raised, and it is not properly before us. We dismiss the appeal for lack of jurisdiction. So that's interpreting the Flores Agreement as still being in effect because the government has not implemented further rules. So the agreement still is the binding order or the binding law. And that agreement requires safe and sanitary conditions and a consideration for the vulnerability of minors, the particular vulnerability of minors. And they apparently knew about this back in July 2015 and did not appeal the part where minors have to be held in unsecure, licensed family detention centers, licensed as in under state law and properly licensed. I mean, you know how a child care facility would you take your child to an unlicensed child care facility? Would you take your child to an uninsured child care facility? Would you take your child to a uninspected child care facility? Well, that's what's happening with the children in these detention centers. These are secure as in a jail. These are unlicensed, uninspected, and unsanitary and unsafe detention centers. And that's somehow okay because we don't like those children. Are you effing kidding me? These are the people I live with in my country. I don't mean all of you. But I mean, like, look around. Like, some of the people around you think it's okay to treat children like this just because we don't like the way that their parents brought them into the country.
And I know that there are people out there that will say something like, well, this is what you get for breaking our laws or whatnot. And I'm like, okay, so the children are not making the decision. They have
this is what you get is for natural consequences. Yeah. This is what you get is what happens when Evel Knievel, drives off a cliff for the 50th time, and this time he misses. Oh, well, play stupid games, win stupid prizes. Sure, make fun of somebody for that. This is what you get does not apply to arbitrary human behavior. To human behavior where people have a power dynamic and control. We have virtually unlimited resources compared to the size of this problem. And we can't even spend a dollar or two per person to give them a toothbrush and toothpaste and turn off the lights. How about this? How about you turn off the lights and the money you save by turning off the lights and letting people sleep? You can give them toothbrushes and toothpaste, no additional cost. Are we kidding? We need to save money for billionaires and oligarchs by hurting children.
Yeah, I think it's cruelty by design that these are policies that have been designed to create these consequences. And it's not like the policy sort of existed and now we're powerless. We have to follow this policy with unintended consequences. I think that the consequences are intended and were designed that way. And we have the power to change the policies.
Yes. And let me explain my personal outrage at this in case you still don't know my story. My parents flew out to Missouri in 1991 to rescue me from a pedophile. And it had been such a strange experience to be in this man's custody to begin with. And then when something actually happened, I was able to get a letter out because guess what? We were banned from contacting anyone. So, oh, gee, I wonder if that was in furtherance of his acts. So I got a letter out, and my parents flew to Missouri to like storm into the building and like grab me and like yell at him and take me away. How could someone do that and then think it's okay to treat someone else's child any differently? Would that person be okay with letting me be neglected in unsafe and unsanitary conditions in a Border Patrol facility that's unlicensed, that's secured like a jail cell, which means visitors can't come in and out, which means inspectors can't come in and out, et cetera, et cetera. And these people would not let it happen to their child, but it is completely okay to do it to someone else's. And it's somehow okay to do it because of a political agenda. So I'm sorry, we don't normally get political, and maybe that touches politics, but this is children we're talking about who will be damaged for the rest of their lives. And you don't think that a marginalized child, having been marginalized by the United States, might not grow up to hate the United States? Are we not making enemies here? Is this really what we want to be doing? Would this have been supported by like someone who is skilled in military strategy? Do we really want to go around making enemies as a valid military strategy? I don't think so. I don't think that that's a valid thing to do. Do we really want to go around making enemies and then saying, "Oh, we've solved the terrorist problem. Look, we made so many enemies." No, you don't. We're not going to be making enemies and then saying that we've done a good thing. No, we could very easily handle the problem and not be the jerks of the world who abuse children. You want to talk about degenerates and deplorables? Yeah, degenerates and deplorables abuse children. And you can go F yourself, people who do that.
America is the only country in the world that did not ratify the United States Human Rights Convention, and is one of the two countries, United States, sorry, and is one of the two countries that did not ratify the Child Rights Convention of the United Nations. The only other country is South Sudan.
We'll be advocating for that as soon as we have a more favorable presidential administration. I don't even need to get political there. Everyone knows this political administration would never join a human rights convention of any kind. In fact, I think he's pulled us out of several.
Yeah, and interestingly enough, quickly reading up, apparently the United Nations Convention on Human Rights, most of them are sort of ratified like in your constitution or state laws. But the one thing that stood out I found interesting is apparently the right to have access to food is not a right in America. That's not in any of the constitution according to my
we just let you die if you can't afford it. Oh well, right? Yeah, what do? I'm starving. You call 911, the ambulance comes. I'm starving, and they go, see ya. Too bad.
That is genuinely what would happen, yeah, if you call 911 because you...
Yeah, they'll wait until you're like emaciated and falling over and, you know, basically incapacitated. Then they'll take you to the hospital and renutriate you after I'm sure that you're not in very good condition anymore.
Yeah, and then you go home, you still don't have food, and now you have a bill for $34,000 in the mail.
Yeah, right.
So
yeah. All right, everybody, that is our show. I am Leonard French, your favorite copyright attorney. I'm off to Glasgow, so thank you for your support as we move Kaylee to Glasgow. We're going to be doing a vlog of some kind, which we will figure out how to post to our YouTube channel. I'll probably end up doing some kind of playlist, and we'll give you the link to the playlist, and then we'll uncheck the notify subscribers thing when we add new videos to the playlist. Or maybe I'll just add unlisted videos to the playlist, and then that way only the playlist subscribers will get notified. How about that? How does that sound? Thank you to our supporters. Without your support, this channel would not be possible. At $500 in the months of July and August, Joshua Davis with TandaPay has supported our channel, and we'll be making a video about his TandaPay service so that hopefully we can help him launch that service into a larger effort. Thank you to the $50 plus supporters: John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Jan Negrey, Blackleaf, Spirit Bear, Daniel Perez, Snorre Wisotzky, NotMike, Joe Tyson, and King Macro. Thank you very much for your support at the $50 level. And thank you to the $5 plus supporters who are also scrolling on the LED panel behind me, along with the other rewards as well. We appreciate all of your support, and let's put some dog video up on the as the crawl goes out here. I'll be doing that vlog with Kaylee starting probably tomorrow or Monday, and we'll see how that goes. So I'll post a link in the description and probably in the outro here. Have a good one. I'm Leonard French, your favorite copyright attorney. With me in the virtual studio today has been Brandon and Kaylee and Technical. Thank you very much to everyone. Have a great day, a great week, and I'll see you in the videos that drop. Love you all. Bye.